morning.
Good morning, may it please the court?
Yes.
My name is Marin, and I'm here on behalf of appellants, Lindsay Investments, and Alexander Marin. We're here on taking appeals from a default order and a default final judgment based on a default order. The argument of the appeal is based on the fact that a default was answered, although a motion to dismiss had priorly been.
Does 1.500C really apply after there's been a stipulated order establishing a filing date?
Yes, Your Honor. There's no case law that says that an agreed order or anything else trumps.
Well, let's just talk about the fairness and the professionalism of it then. Let's just go through the dates. Now, you started out with a response date of 20 days after service, but you negotiated and got a court order giving you a later date of April something, correct?
Right, correct. Yes.
Right. Well, you don't file any response pleading before that date, correct?
Right.
You go a few more days, not a few more days, really about 3 weeks, and then you file the day before a hearing on the default, you file a motion to dismiss, which says that it was served by mail. So how is your opposing counsel going to get it if it's served by mail before the hearing?
Well, I don't know if this is a stipulated fact, but the motion to dismiss was faxed
at 8:15 that night. I see that. I see that. I'm going by your certificate, but let's give you the benefit of that break. You file it by fax at 8:15. What if the lawyer goes to court and just goes directly to the motion calendar hearing?
Well, actually, what happened in that case is that the motion to dismiss was entered into the court docket prior to the hearing.
Oh yes, it was filed at 8:27, I think. It was filed at 8:18, so that's. You think that's sufficient? If you file it downstairs in the clerk's office, it gets stamped in.
Well,
does anybody see it and actually read it when it?
And I think this is what the first judge, Judge Israel Reyes, because this motion, we filed the motion to dismiss. We didn't even attend the hearing. We attended the hearing by phone.
What was the basis of the motion to dismiss?
Actually, notwithstanding, and this fact was taken over by the FDIC. The FDIC has certain requirements to have a.
And in a federal bank takeover case, everybody knows Dinstune, everybody knows 1823, that there are it's a holder in due course doctrine. So,
but Your Honor, we don't get there. We don't get to the meritorious defense argument. We don't get to
because this is talismanic. This is talismanic. It leaves nobody any discretion. If you file something 1 instant
yes, Your Honor,
before that default order is your theory,
no,
you're done.
That is absolutely not the law. The law is that you're entitled to a hearing.
Even a notice of appearance?
Well, the case that we have on point from the third DCA, Your Honor, and we have a line of cases there, and they're specifically, and let me just read from the case, it says, a party may plead or otherwise defend at any time before default is entered. It is plain that an order may not be deemed to have been answered, notwithstanding its having been signed by the court until it's actually filed.
You didn't plead. You filed a motion to dismiss, giving that the best. If you pled before the default and there's no default, you didn't plead. But filed a spurious motion that was late. That was an obvious attempt to get more time than you had already negotiated, which you violated. Now this is, you know.
A response.
Are you familiar with the term chutzpah?
Pardon?
Are you familiar with the term chutzpah?
No, Your Honor.
You're not. Chutzpah means unbelievable gall. Unbelievable gall that you should be here.
Well, Your Honor,
are you the person who filed the motion?
Yes, Your Honor.
And you're the person who took this appeal?
Yes, Your Honor.
Today is like Ethics Day, which is great for the interns who join us in the summer, but don't you see the problem? Law is not a game. In foreclosures, your client benefits. If you drag things out, your client can stay in possession. There are lots of things going on. But lawyers between themselves, you know, you've got to be responsive, you've got to file pleadings on time. You just have to do those things. You can't use some perceived technicality and then sandbag opposing counsel the day of the hearing.
But Your Honor, I think in this case, you know, the defenses are there, that the motion to dismiss, even though we don't get to that argument, I don't think, even though our position is that the lower court does not have discretion.
Did you have a transcript for the hearing?
We have a transcript from the second hearing, which is where.
Do you have a transcript for the hearing of April 27, 2011?
The first hearing, no.
Okay.
It was over.
That's where the court set the deadline for you to file.
No.
Right?
That's the
hearing where the motion for the default was
answered.
Okay.
Right. That was in order, and then, since the judge didn't think had the, availability to know whether the motion to dismiss had been filed or not, that's, I think, why he answered the order saying, well, you have up to certain days to move
What
to
has
vacate.
happened to the property? What has happened to the foreclosure?
The property right now, it was going to sell on the 2nd of July, however, that was canceled because the FDIC, there's a third property that is subject to, that is in the collateral, and that property was not approved.
It has nothing to do with the tendency of this proceeding.
No, Your Honor. The FDIC had not approved, from what I understand, the sale of the three properties as
But if you win this case, if you win this appeal, then all that has to be set aside, of course.
Yes, Your Honor.
But after the default was entered on April 27th of 2011, would it not have been prudent to follow the procedure for trying to vacate a default ordinarily? Namely, I have meritorious defenses. They are as follows. It's excusable neglect.
Your Honor,
I've been diligent.
We feel that we don't get there.
I understand that
And I have a case in point.
Assuming that you're wrong, which is not an assumption, you're wrong about that. Isn't it a better idea, even if you're right about it? Even if you're right about it, to go about it in a way which doesn't cause a 4-year delay?
Well, Your Honor, we also have a case from the third DCA here. It's a magic organization name.
Counsel,
So you're going to answer that question directly. Is it better to do things the way that the rules envisioned? In other words, the ceiling, not the floor.
Right.
Both the spirit and the express language. Or are you better off creating an appellate issue which would serve to maintain the status quo?
No, Your Honor. No, Your Honor. And I do agree that the way that the rules envisioned should be the way that it is followed. And to that end, I plead that conversations with the opposing counsel from day one were just have this motion to dismiss answer and let's go through the procedure, let's go through the discovery, let's go through the case, let's not lose a year of time in this appeal. And let's just go forward. This case would have been decided a long time ago if this had not been an issue. This case could have been decided way over the last course of the year. And I think opposing counsels, and I think not opposing counsel, but the plaintiff in this case, the police, just decided, well, let's just take our chances and on this appeal. I think
that was a very wise decision on that part.
Your Honor, I have one case here that I just want to point out is that going back to your question.
Is it in the brief? Is it in your brief?
It is, yes.
So you might be better off reserving your rebuttal.
Well, tell us the name of it and
it's in Chester. It's within it, and it says that the order of default was erroneous. Since the order of default was erroneous, a final default judgment must be set aside, even if the appellate argues the defendant did not show a meritorious defense in support of his motion to vacate. And this is going to the question that you have posed.
And was that after the parties had stipulated to an order setting a deadline?
Well, Your Honor, I
yes
think...
or no? Was that case?
No, Your Honor.
Thank you.
All right. Thank you.
Rather, I don't think even you can snatch the fee from the judge of this.
Well, thank you, Your Honor. That's a tremendous compliment, and I appreciate that. I believe the court has recognized the issues here, unless the court has any questions.
Do you want to distinguish Chester for us? Do you want to address the Chester case?
Your Honor,
out of our district?
I think what's important for the court to note, and I'll address Your Honor's question. The distinction here is, I think Judge Salter, I think you pointed this out as well, this is a case where there was a specific court-ordered deadline. This is not a garden variety failure to respond. A court orders a deadline by date certain. The appellant admittedly violates that rule. On the morning of a hearing, attempts to file something that, as Judge Schwartz noted, is spurious at best. The verified complaint clearly establishes standing, as Your Honor noted, through the FDIC, the receivership process, the debt student doctrine, Section 1823, which is in our brief. There's no question about standing. There is no doubt that here the appellant violated a court-ordered deadline and then have no transcript of the proceedings to overcome the presumption of correctness, have not filed any sworn statements or affidavits to support a claim of excusable neglect, and have not demonstrated a meritorious defense. So, Your Honor, I hope that I have satisfied the concern you expressed.
Now that you raised those issues, there's a certain doubt in my mind.
Thank you, Your Honor. I appreciate your time today.
Thank you very much.
Your Honor, if I may, Rule 1.50C does not distinguish between somebody that hasn't filed within the 20 days or somebody that hasn't filed because of a court order. It doesn't distinguish. It only goes to a default. Sanctions in this case, even if it was a sanction in this case, the sanction was not to strike the answer or to strike the response, to strike any pleadings and then default us. It was just merely it's just when it goes to what a default means. A default means that if you had not responded by a certain amount of time, whether it is by the 20-day prescribed rule or by a court order for an extension of time, it doesn't distinguish that, Your Honor. The sanctions, and I don't think this was a sanction in this case, the opposing brief says that it's a sanction merely because the second judge who took the motion to vacate interpreted the judge's Reyes order to be a sanction. And that was his interpretation, saying, well, this was a sanction.
Well, we could assess it under Cozell, except that we don't have a transcript. So
well, we don't have it for the second one.
We don't have a transcript for the first one, and so we can't tell what was going through that judge's head at that hearing.
Even if it was a sanction, even if it was a court order, that allowed, the default, the rule does not differentiate for any of those. And the rule just simply states strictly that, and we have case law that supports that rule that you have until that day, until the court is actually, the judge may even sign, because obviously this happened before. And I know that
you could have run into the hearing with it and given it to the judge later on his death as he's signing the default.
Judge, you haven't signed the default. Here's the response.
And he could handwrite it on a piece of paper. Wait, hold on a second. Could you do that? Could you take out a notepad, and while the judge announces it in court, I am now signing the default, you could handwrite motion to dismiss, specific details to be raised at a later hearing, sign it, and hand it to him and say, Judge, this is my motion. Would you do that? Well, hang on a second, because I know your question, but just wait so I know you're answering the question I'm asking. Under 1.500C, would you be able to say that you've met those requirements and the judge would be prohibited from...
No, Your Honor, I think the rule...
Why would you not?
Well, the rule says very specifically answer, and the cases go to what answer means. And answer means...
This is not answer, does not mean a motion by the clerk.
So if you ran in and gave the clerk, that'd be okay, but not in front of the judge.
Right.
Very good. Thank you. So if you do want to say...
In conclusion, we request that the motion to dismiss be considered timely in this case, as it was entered prior to the fall being ordered, and that we remand to allow for the motion to dismiss to be considered and the case to go forward.
Very good. Thank you both.